The subcommittee on new offenses and change penalties will come to order. The clerk will call the roll.
Chair Louderback. Here.
Here.
Representative Bowers. Representative Little.
Here.
Representative Money. Representative Moody.
Quorum is present. As a reminder, anyone present wishing to testify before this committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please with the committee staff. Katie will be glad to help you. Due to the number of bills on our agenda to accommodate all who wish to testify, there will be a time limit of 2 minutes per witness during the public testimony period. Please keep your remarks within that time frame. With that, we will begin. The chair lays out Senate Bill 230 and recognizes Chairman Guerin to explain the bill.
2320.
230.
Okay. 2320, I believe.
2320. Oh, I see. Okay, a little typo.
Thank you, Mr. Chairman.
Absolutely.
Members, Senate Bill 2320 amends the penal code to enhance the penalties for all DWI offenses, including first-time offenders, offenses with open container present in the vehicle, offenses in which the driver's alcohol concentration level was 0.15 or more, and repeat offenses. And the reason I'm carrying this bill, on November 22nd of 23, Lauren McElroy, her husband Zach, and their 12-year-old son Judson and 9-year-old daughter Lindsay were driving from Fort Worth to Johnson City to celebrate Thanksgiving. They never arrived. A vehicle driven by a drunk driver crossed Highway 281, collided head-on with Lauren and her family. Lauren was seriously injured and airlifted to Seton in Austin. Unfortunately, Zach, Judson, and Lindsay did not survive. 3 months later, Lauren learned the driver of the other vehicle had a blood alcohol content of 0.261, more than 3 times the legal limit. The consequences of driving while intoxicated endanger the lives of every person on the road, and too many Texans have become victims. This bill is about protecting our children, grandchildren, and loved ones, and it substantially increases the penalties. And if you have any question about that, they're in the bill, but if you have any questions, I'll be happy to try to answer them.
Questions, Mr. Chairman? Thank you, sir.
Thank you.
If there are no further questions, Chair will move on to witness testimony. The Chair calls Mark Thiessen, representing self. Okay. You're registered as Mark Thiessen, representing yourself.
Yes,
You're
sir.
on for or against the bill?
I'm against the bill.
Against the bill. Thank you. Go ahead.
So why you can trust me this morning is because this is against my best financial interest. I am one of 5 DWI specialist defense attorneys in the state of Texas. This is bad for my business, but I'm here to tell you the truth about this. People say, Mark, how can you represent DWI clients? Because you don't have to be a bad person to get a DWI. I've represented, we all know friends that have DWIs. I've represented police, doctors, lawyers, politicians, judges. In fact, our beloved ex-governor, George Bush, has a DUI. And he talks about it, how intoxicated he was. He was probably over a 0.15 when he drank too much with John Newcomb. That would make him a felony back in the day. This bill doesn't take into account how hospital blood is always falsely elevated. It doesn't take into account the rising problem of people driving on drugs and medication. 0.15 won't deal with that. I'm only here to talk about the 0.15. And Texas has been an at the time of driving state. When you get these numbers, it isn't at the time of driving, so we're going to change all kinds of law. I completely agree that felonies should be for intox manslaughter, intox assaults. When you have multiple DWIs, we're not here about that. But to make it a felony over a 0.15 is going to ruin a lot of lives. We know people like that. We have our friends. We have politicians that had it. So I believe that this bill will ruin, strictly only because of the 0.15 making it a felony, will ruin more lives than deter it, because honestly, being in the trenches, what's going to happen when they make that a felony, they're just going to plead it down to a misdemeanor. They're just going to, it's not going to do anything. It's not going to deter DWIs. Keep felonies for everything else, but please do not make 0.15 on a DWI first a felony. Thank you very much.
Members, are there any questions for this witness?
Yes, sir.
Representative Little.
Thank you, Chairman. I don't know how much you see this in your practice, but it seems to me, or one of the things that I observe about other people is that it's not so much the level of intoxication from alcohol, but that people are mixing that with benzos and other drugs. And I mean, they don't need to be 0.15 to be way more intoxicated than somebody is 0.08 mixed with other prescription medication. Do you see that in your practice?
I think it's rising right now. We're getting a lot more medication and weed and all the different drugs. But here's the problem with all the so a 0.15 won't catch any of those drugs, right?
That's what I'm saying.
But the problem is on the 0.1, well, I am seeing all of that, and it's not going to catch it. So maybe more people are going to be like, well, I'm just going to keep taking my medication. And the problem is there is no magic number for these pills. Just because you took a Xanax yesterday to relax after work, you're still testing positive the next day, even though it's not psychoactive. And so just because it's in your blood for the next 3 days and it's going to show with that alcohol content, it's not necessarily psychoactive. Just because you took a hydrocodone this weekend for knee pain, you're still testing positive today, you know, as it gets out of your system, but it's not necessarily psychoactive with the alcohol.
Okay, thank you.
No problem. Anything else?
Any other questions? Thank you, sir.
Thank you very much.
The chair calls Douglas Huff, representing self. You're registered as Douglas Huff,
Yes,
representing yourself? And
Yes,
you're-
I am.
And you're on for or against the bill?
I'm against the bill.
Okay, thank you. Go ahead.
My name is Douglas Huff. I'm a defense attorney as well, based out of Dallas, Texas. I strongly oppose the Bill 2320 because it escalates punishment for first-time DWI offenders without improving public safety, and it strains our already overloaded courts and jail systems and removes flexibility for the justice that justice demands. First, the bill will elevate first-time DWIs from a Class B to a Class A misdemeanor, and in some cases to a state jail felony. That's a massive leap in punishment for people who, in many cases, made a mistake but were not involved in an accident, didn't harm anyone, and often had no previous criminal history. Second, the bill would make it a state jail felony if a person's blood alcohol content is over 0.05 or more, and even on a first offense. That means someone who has 2 or 3 drinks too many can now be branded a felon for life. This isn't targeting repeat offenders or people who cause harm. This does not target intox manslaughters or assaults. It's punishing statistical risk with lifelong consequences. Third, the bill elevates a second DWI to a state jail felony regardless of how long the first one occurred. I've represented clients with DWIs in their early 20s, and then 20, 30 years later, they are charged with a DWI, and this law would force a felony on someone who's lived clean for decades. To be clear, we support laws against dangerous repeat DWI conduct, but felony convictions destroy careers, it limits housing, it devastates families and career opportunities. I urge you not to turn thousands of working Texans into felons, and I'm asking for you to reject 2320. Thank you.
Thank you. Any questions?
Sure.
Mr. Little?
How much of the DWI docket does this shift from county court at law to district court?
I think it would shift a massive amount from county court to district court, because now, as soon as we move anything to state jail felony,
It automatically goes to district court,
it's
right?
going to district court.
And so what is the volume that we're talking about? Do you,
I
as
can't
a
speak.
practitioner, feel like you have a sense of that?
I mean, I can give you a sense of it. I mean, just thinking about the 0.15 or greater or second-time DWI that would now be considered, now that we're going into a state jail felony, I would imagine just from the docket that I normally work, that's going to change half of my caseload from misdemeanor to felony. That's moving things from county court to district courts. That's going to put an incredible burden on our judicial system.
It would be massive.
It would be massive.
Okay. Thank you.
Thank you.
Any other additional questions?
Chair would like to recognize Representative Bowers in attendance. Thank you, sir.
Thank you.
Chair calls David Gonzalez. Mr. Gonzalez, you show registered as David Gonzalez, Texas Criminal Defense Lawyers Association, and self?
Yes, sir.
That's correct. And are you testifying on for or against the bill?
I'm testifying against the bill.
Okay, thank you. Go ahead.
The Texas Criminal Defense Lawyers Association typically doesn't weigh in on enhancement provisions. That's your job. But here's why we're chiming in on this one, for two reasons. First, is this is the first time that the proof changes the offense. So if I have a lot of proof over a .08, then at that point it makes it a more serious offense, unlike theft or burglary or robbery. So in other words, if I confess or if I cooperate, at that point I now have a greater penalty than if I refuse to give a breath or a blood test, and you can't be able to get that against me. And so what that changes are the incentives for people to cooperate with the police. And so, for example, in Travis County, a lot of our programs for diversion have been, if you're not rude to the officer, if you consent to breath or blood, you agree to have interlock in your car, you can have one path. Instead, this now changes that to how we used to be 10 years ago, where lawyers are saying, look, there is no incentive to cooperate or give breath or blood. You're only giving an incentive to take a misdemeanor into a felony. So that changes the first thing. The second is, for many of us who see these cases, I say typically for representing women who have no concept that 2 glasses of wine can very quickly get you into much higher BACs than you thought. And so it's the behavior that we look to disincentivize, not the actual amount that metabolizes in your bloodstream. As for many of my clients who have felt when they started driving that they were okay, and then they pulled over because something wasn't seeming correct, and they're in the side of the road and they're not driving, they're still arrested because the officer's like, well, you used to be driving. I would like to incentivize the people that feel like they're too intoxicated to pull over, but now the very folks that feel that and pull over that have a high BAC are the ones that now are subjected to felony punishment as compared to what's happening right now, which is misdemeanors or diversion. It dramatically changes, I think, both county court versus district court, and just a lot of incentives of what now we lawyers are going to advise people on whether you should give a breath or a blood test.
Members, questions? Thank you, sir.
Thank you.
Chair calls C.J. Grisham. You registered as C.J. Grisham, and you're here representing yourself?
That's correct. Yes,
Thank
Mr.
you. And you're on for or against the bill?
I'm against the bill, Sheriff.
Against the bill, thank you.
Oh, it should be against. I am against.
Do we have your permission to change it?
Yes, you do.
Thank you.
Um,
Go ahead.
Thank you. So I'm mostly a civil rights attorney, but I'm also a criminal defense attorney, generally as it relates to civil rights issues. I don't do DUIs and DWIs, and the reason I don't is because I don't want people out there threatening my life, threatening my kid's life, out there drinking and driving. But I make exceptions, first-time offenses. If it's a first-time offense and you come to me and say, CJ, help me, I screwed up, I made a mistake. Whether it's .02 or .19, it doesn't matter to me. If you make a mistake, this happens to people. And there's various reasons for that, a death in the family, the loss of a job, you know, and that doesn't excuse it. But when I have a client that comes to me and says, I screwed up, I want to take responsibility for my actions, I just need an attorney to help me so it doesn't ruin my life, this will ruin people's lives. And that one mistake is now a lifetime mistake. Now, I agree with one of the previous attorneys that spoke about intoxicated manslaughter and, you know, when someone's hurt or killed because of this drinking and driving, I'm for the death penalty in those cases. But when it's just the fact that you have a blood alcohol content in your system, and especially if it's a first offense, I think this affects their right to keep and bear arms. It affects their right to get loans. It affects their right to get jobs, or their ability to get jobs. It affects their ability to go to school. And for that reason, I oppose the bill. Although I understand we've got to do something about drinking and driving, but I don't think making it a felony is the way to do it. So I respectfully, on my own behalf, oppose the bill.
Thank you. Members, questions? Thanks, sir.
Thank you.
Chair calls Timothy Mabry. Timothy Mabry, registered as self for the bill. We'll show him not in attendance and not testifying. That's it. Is anyone else who wishes to testify on, for, or against Senate Bill 2320? If not, the chair recognizes Representative Guerin to close on the bill.
Thank you, Mr. Chairman. Members, I'm really happy to hear from these defense lawyers today. I wish they'd come by earlier and we could have talked about this. I don't disagree with them. We possibly can make some changes in this bill for first-time offenders that don't hurt or kill somebody. If you have any questions, I'll be happy to answer them, and if not, I'll close.
Sure.
Representative Moody has a question.
Chairman Garrett, it's not a question, but I'm wondering if we could get data from Office of Court Administration. I see the fiscal note in there. They're extrapolating out over there, but they should be able to tell us in the previous few calendar years which ones were filed I just don't know if they can disaggregate the data between because these would be A's today, but also A's are second offenses. So I don't know if they can disaggregate A second offense versus A high BAC. But if they can, or if they're listening with, maybe they're just watching us all the time, I would love to have that information just to know, just to have the case number. So if that's something that we can work on getting, that would be helpful.
Mr. Moody, I'll be happy to try to do that, and I hope they're not watching us all the time. They need something better to do.
You'd be amazed sometimes. They're like, I heard you ask this question. I'm like, well, what else? All right. Anyway, thank you, Mr. Chairman.
Representative Bowers.
Thank you, Mr. Chairman, and thank you, Chairman Guerin. I think we've been having this discussion for a minute now about drunk drivers. So I'm really grateful that you brought this legislation and have picked this up. I'm wondering about the projected impact on incarceration, though. Do you have any information or data on if it?
Ma'am, I don't, but I'll try to get that for you.
Okay, just thinking about TDCJ bed increase and if there will be projected overcrowding.
I'll be happy to try to get that. I mean, this was brought to me as a really good Fort Worth family that was affected by this, and it's personal to me, and I'll admit that. But I'm happy to work with with some defense attorneys, and I've got some good friends that are DWI defense attorneys in Fort Worth, and I'm happy to work with that. I just wish that they'd come to us before today.
Thank you. Thank you so much.
Thank you, Chairman.
Thank you. I'll close.
If there's no objection, hearing none,
Thank you.
Senate Bill 2320 is left pending. Chair lays out Senate Bill 1362 and recognizes Chairman Hefner to explain the bill.
Thank you, Mr. Chairman. And members, thank you all for the opportunity to lay out Senate Bill 1362 today. Senate Bill 1362, known as the Anti-Red Flag Act, safeguards Texas constitutional rights by banning the recognition or enforcement of red flag orders, also called extreme risk protective orders, in Texas. It reinforces Texas' commitment to protecting the rights of law-abiding citizens while ensuring due process for all Texans. The Anti-Red Flag Act prevents all governmental entities in Texas from recognizing or enforcing red flag orders unless explicitly authorized by Texas law. Furthermore, the bill prohibits Texas entities from accepting federal funds to enforce red flag laws in this state. To clarify, family violence protective orders or magistrates' orders of emergency protection are specifically authorized and are not affected. Senate Bill 1362 seeks to place a prohibition on local regulation by stopping all governmental entities or officials from adopting or enforcing rules, ordinances, orders, policies, or measures regarding red flag orders unless explicitly permitted by state law. Ensuring that any federal statute, order, rule, or regulation enforcing a red flag order that violates rights protected by the protected by the United States or Texas constitutions is enforceable and has no effect in Texas. Senate Bill 1362 places a prohibition on accepting federal grants by barring the acceptance of federal money to implement, enforce, or administer federal red flag statutes, orders, rules, or regulations. The Red Flag Act creates a criminal offense, a state jail felony for anyone to enforce or attempt to enforce a red flag order against a person in Texas unless the order was issued explicitly under Texas law. Thank you for your time. Be happy to answer any questions, and I'd like to close.
Members, any questions for Chairman?
Just a quick
Chair
question.
Moody.
Was reviewing some information, and according to the National Instant Criminal Background Check System Report 2022, Texas is one of 28 states that does not have emergency risk protective order or red flag statute in place. But this is a state that through under full faith and credit will honor those issued by other states. What does your bill do to that?
You
in
know,
terms of
that
honoring
is something
things
I
under
would
full
have
faith and
to,
credit?
I'd have to do some research on, Mr. Moody and get back to
Okay,
you on that.
I'd
That's
love to dig
interesting.
into that with you, and
Yeah,
I
it's-
know it's early and we've got a lot of stuff going on these days, but if we could touch base on that,
Yeah,
I'd
that's something
appreciate
I'd have
it.
to dig into. Be happy to work with you on that.
Thank you.
Questions? Representative Bowers.
Thank you, Chairman Lauterbach. Chairman Hefner, wondering how this legislation might impact public safety efforts tied to domestic violence and mental health. Y'all know I've had a number of domestic violence bills this session, and just wondering how you think this legislation might impact public safety and domestic violence efforts.
You know, I think what the bill aims to do is to ensure and safeguard that we are enforcing current law and not expanding that into these extreme risk protective orders that are not explicitly authorized by law. So, to me, it just helps to strengthen due process and protect the rights of law-abiding citizens. And you know, we just need to enforce the laws on the books, and we don't need, you know, magistrates or judges determining without due process somebody's constitutional rights.
Okay. Are there plans or proposals for Texas-specific alternatives that offer similar preemptive protections, maybe?
You know, not that I'm aware of. Like I said, we're just seeking to make sure that we do everything according to existing state law.
Thank you so very much.
Members, any other questions?
I'm so sorry.
Chair Moody.
And not so much of a question as a comment, because I've carried legislation like this. I was asked to first look into it when I was still allowed to be a chairman by the governor at the time. And so we had, 6 hours of hearing on this topic. And so the one thing I want to clarify, and this is just me being a nerd and a lawyer, but people talk about no due process, no due process, no due process in these settings. The argument, if we want to have one, is whether or not they provide sufficient due process, because those structures have mechanisms of due process. They were the same as what we mirror in our protective order laws that we use, like that you stated in domestic violence cases. It is mirrored right over into these extreme risk protective order laws. So there is due process in there. Whether people want to argue whether it is sufficient enough to deprive someone of their firearm, then that's where we get into the conversation. So again, I am not nitpicking your language. It's just I've had this conversation so many times. People get into buzzword stuff in these dialogues, and I want to get down to that's really what we're talking about. No due process would be someone coming up and snatching it out of your hand, and so if there is a court process involved, you may not think that is sufficient, and that's okay. Let's talk about that. But I want to get out of the kind of more hyperbolic that this is some sort of, property grab without any due process, because the bills are built to have process. So anyway, that's not directed at you. Just over years of having this conversation, this is just a frustration I've had. Thank you.
Thank you, Mr. Speaker.
Members, any other questions? Thank you. Chair will move on to witness testimony. Chair calls Lily Ortiz. Ms. Ortiz, you're registered as Lily Ortiz, representing yourself,
Yes.
and you are on for or against the bill?
Against.
Against the bill.
Opposition.
Thank you. Go ahead.
Quite honestly, y'all, I'm having a bit of trouble understanding how this legislation would help anyone, absolutely anyone in Texas, besides people who sell guns. It helps absolutely no one else. It makes every single one of us less safe, knowing that people who have court orders against them in other states will be allowed to come and buy them here. SB 1362 would also affect our people who serve in law enforcement here in Texas. How could this bill not make their jobs even more difficult and put them in even more danger? There are more chances of situations getting out of control, and this bill would actually do them more harm than I think good. Because we can actually look to other states and see results and data, we know that these laws are extremely important in reducing gun-related violence. In fact, they're instrumental. I volunteered for a short period of time as a crisis counselor, and it was one of the most difficult things I've ever done. The saddest thing above all was that we didn't have enough volunteers at the time for the amount of call volume coming through. So that meant people in crisis were left on hold for hours. What that means is people want to live, actually, when they're calling in times of ideation. They just need help. Red flag laws decrease suicides. That's a fact. I respect the Second Amendment. I grew up around guns my entire life. Not passing this legislation, as Moody said, doesn't infringe on anyone's rights, and people need our help. So please vote against advancing this bill. I don't think we need to. Thank you.
Members, questions? Thank you. Chair calls Nick Tucio. We show you registered as Nick Tucio, representing the National Rifle Association,
Yes, sir.
and you are on for or against the bill?
I'm for.
For the bill. Thank you. Go ahead.
Of course. Chairman, members of the committee, my name is Nick Tuccio, State Director of the National Rifle Association, here to speak in strong support of Senate Bill 1362, aptly named the Anti-Red Flag Act. This critical legislation is essential for protecting the constitutional rights of law-abiding Texans. SB 1362 wisely prohibits the recognition, service, and enforcement of what the bill defines as, quote, extreme risk protective orders. It is absolutely vital to recognize that the orders that this bill addresses are specifically defined as those not issued on the basis of conduct that resulted in a criminal charge for the person who is subject to the order. The NRA staunchly believes that the removal of a person's fundamental, constitutionally protected right to keep and bear arms must occur only through a process that rigorously respects due process and the rule of law. Orders that circumvent a criminal charge remove firearms from citizens without the robust protections and standards of evidence inherent in the criminal justice system. Furthermore, 1362 correctly establishes that federal statutes, orders, rules, or regulations purporting to implement or enforce such orders in Texas that infringe on a person's right of due process, keeping and bearing arms, or free speech are unenforceable as against the public policy of the state. The bill also prevents state and local entities from accepting federal grant funds for the implementation or enforcement of these measures. This is a necessary assertion of Texas sovereignty against federal mandates that seek to erode our constitutional freedoms. By creating a criminal offense for serving or enforcing these specific types of orders unless issued under Texas law, this bill provides a crucial layer of protection for Texans against potential overreach and abuse. I urge you to support Senate Bill 1362. Thank you very much.
Members, questions? Thanks, sir.
Thank you.
Chair calls Molly Boyles. We show you registered as Molly Boyles, Director of Public Policy, Texas Council on Family Violence. And we show you neutral on the bill.
Yes, that's correct. Good morning, everyone.
That's correct.
Thank y'all
Thank
for your time. My name is Molly Boyles. I'm the Director of Public Policy at the Texas Council on Family Violence. We have the privilege of representing member programs all over the state, thousands of Texans and survivors. I'm neutral on the bill because we have had the practice at TCFU when we're working with an author on a substitute or potential language change, and we have appreciated Senator Hughes's office for collaborating with us. While we understand this measure directly relates to emergency high-risk protective orders, of which I bet others will speak to their known efficacy, I want to speak to the intersection with domestic violence protective orders and appreciate y'all raising it, and appreciate Chair Hefner also raising it. In its current iteration, I have received multiple emails, questions, and concerns, not just from survivors, but from district attorneys and county attorneys, judges who think this will cause a great deal of confusion to the applicability of domestic violence protective orders. Again, we appreciate consulting with the Senator's staff. They've been great to hear our concerns, have them raised, and you all may have seen Senator Hughes even himself said, quote, family violence protective orders are not affected by this bill, and that's very important. Further, he said family violence protective orders, like you were describing, those are specifically authorized. We are appreciative of this clarification on the floor, but we believe it's critical that this measure be completely explicit so there can be no confusion to all the people contacting us. Y'all have done amazing work this session, certainly you, Representative Bowers, but all of you, to make sure these protective orders that save lives are fully implemented. I know I've mentioned this to you before, but leaving is the most dangerous time. And over half the time when someone is murdered in their state, our state, by an intimate partner, they are in a stage of leaving and probably have a protective order. They pursue these because their life is threatened. It's critical we make sure they're upheld. They will prevent homicides in our state, undoubtedly. We reiterate our thanks. We implore you that if you do decide to move this out of this committee, that you only do so with an explicit provision about the enforceability of protective orders under the Family Code, the Code of Criminal Procedures, or any other order from a state that's related to those. And I'm happy to answer any questions.
Members, questions? Representative Bowers.
Thank you. Thank you, Mr. Chairman, and thank you, Molly Voiles. Thank you so much for being here today. And, thank you for sharing that Senator Hughes as well as Chairman Hefner have been great to work with. And I have great respect for both of them as well. And, one thing that I know about Chairman Hefner is that even if we don't agree or we're not completely aligned, that he's always been willing to talk it through and agree to disagree or find a place of common ground. So thank you for that. And I think my concern has to deal with what you shared as well as what Ms. Ortiz shared before you, just about the under-resourced communities that may be affected when it comes to gun violence and domestic abuse. So thank you both, and thank you for what you shared. Thank you, Mr. Chairman.
I concur. Thank you, Representative. Thank you, Chair, for specifically mentioning that, and we look forward to a substitute that would make it really clear. Thank you.
Thank you. Chair calls Kimberly Moyers. We showed you registered as Kimberly Moyers, representing yourself,
Yes, sir.
and you registered for the bill.
Yes, sir.
Thank you. Go ahead.
My name is Kimberly Tyken Moyers. I'm a United States Navy disabled veteran. On January 28, 2025, Senator Tommy Tuberville said, "You're even arresting veterans and driving them away from their appointments." That is exactly what happened to me at Conroe, VA, by Conroe PD. My cases in state and federal were dismissed. The Department of Veteran Affairs carries out red flag policies on its veterans as seen in their patient record flag manual via the Disruptive Behavior Committee. They do not use their own police. They use state and local law enforcement to carry it out as seen in the public information request that I do have here. I will turn it in. They used to combat these policies, Congressman Moore Luttrell itself and push the Veteran Second Amendment Protection Act, the Veteran Second Amendment Restoration Act, and Lauren Boebert with the Shall Not Be Infringed Act. The VA puts a flag on our medical records and rules us disruptive by bureaucrats. We do not get due process. We're arrested, OIG comes at our house, and just guilty. And we have to prove ourselves innocent. Majority of the VA police are not trained in these risk protections, which were revealed in a congressional hearing in 2019. Congressman Luttrell revealed that again in the summer of last year. Therefore, our local PD are also carrying out poor training on behest of VA police. There is no labor and delivery department and never was in the VA. They gave me a porta potty to have a baby. Women's Health Director Emily Ashbaugh enacted horrible vernacular that would take away my identity as a woman, and it was considered hate speech. Abortion in the VA set the tone where carrying a baby isn't even considered life at all. These tones impacted VA culture to the point where I was disregarded. My child was disregarded. And I was almost killed, and my daughter. This is what set off my red flags. Corrupt employees abuse risk protection orders. The narrative that you take a veteran gun away, you save lives, has not changed, but the suicide rate has been consistent, and it was revealed by Congresswoman Miller Meeks 8 days ago on the House committee floor. It's 17 vets a day for the VA. That's minus DOD, but it's 20 veterans a day for overdose. VA isn't concerned about the overdose, by the way.
Please wrap it up.
Huh?
Please wrap it up.
Yes, sir. Mr. Bob Carey from the National Defense Committee even testified before Congress, risk protections on veterans was a solution in search of a problem. There are 270,000 veterans that are red flagged without due process. I am one of them, and I appreciate your time. Please vote yes on this bill.
Thank you. Members' questions? Representative Little.
Thank you, Chairman. Kimberly, this is exactly what I wanted, okay? We got the pro-gun people on one side, we got the anti-gun people on one side. You're a person who's been affected by this, it sounds like.
Yes, sir.
You have to excuse my ignorance. I'm not living out your circumstances. Can you explain how this happened to you? Like how you ended up with a red flag and what that looks like?
Okay, so what they do is they rule you disruptive by a disruptive behavior committee you're not allowed to go to. And it's kind of used under Brady law to rule you kind of a mental defect. They put it inside your medical record, and when you show up at the VA police put that red flag on you. It is a gun grab.
For what? Like, what are the reasons that the VA uses to
It can
put
be
this on?
anything, any destabilizing event, mention of guns and firearms, mentions of relocations of firearms, and in the VA patient record flag manual, it says to hit females 10 times harder.
Okay, now we're talking about due process.
Yeah.
So you go to the VA, you say some things that upset some bureaucrats, and they go back in a room and decide that you shouldn't have a gun?
Yes.
I don't have any more questions. Thank you.
Members? Thank you.
Thank you, sir. Appreciate your time. Do you want me to turn in everything?
Certainly can. Chair calls C.J. Grisham. C.J., we show you registered to C.J. Grisham, Texas Gun Rights and Self.
Yes, sir.
And for the bill.
Just lost my... Hang on, I'm sorry. Let me pull it up on my pad just turned off, but it's easier to get it on my phone.
Thank you. Go
Thank
ahead,
you,
William.
Mr. Sheriff. Sheriff, you'll always be sheriff to me, Sheriff. And thank you, Chair Hefner, for bringing this bill. My name is C.J. Grisham. I am the legal counsel for Texas Gun Rights, and I'm here to testify in favor of 1362 for both myself and Texas Gun Rights. Currently, 19 states and the District of Columbia, as of 2024, have red flag laws and ERPOs. These allow police, family members, and individuals living in the same residence and others to file a petition for a court order. It's very difficult for us to come here and say what exactly is being banned because there's no standard for an ERPO. There are some places where literally if a neighbor just says that, presents some affidavit, boom, there you go, ERPO. And there are some states that require even more due process, for example, going through a court process. And then there's the Trump standard of take the guns and worry about due process later. However, it is possible that these laws, but what I will tell you is that I have statistics that ERPOs don't reduce violent crime, they don't reduce family crime, family violence, they don't reduce suicide. I think I heard testimony about it reduces suicide. You know what it reduces? It reduces firearm suicide. But suicide rates overall don't reduce. They just changed the method by which they're going to commit suicide. And in fact, there is some evidence that suggests that suicide rates go up with an ERPO because now you've not only told this guy that you're a menace to society and a threat and a danger, but you've also taken his only means of self-defense, which only serves to aggravate the matter even more. The laws are specifically limited to people who are not specifically limited to people who are mentally ill, as there are already options to commit those posing a danger to themselves or others. Domestic violence is already a discriminator for those to have firearms. So if you're convicted of a domestic violence offense, you're already a prohibited person. So this wouldn't affect that. But ERPOs are meant to let people determine on their own whether someone is dangerous. And again, it depends on what the ERPO looks like. We don't have one in Texas, so we can't really say what is it going to look like in Texas. But we can look at other states where literally it's just someone that makes an affidavit and files it with the police. There's your ERPO. So while there are already laws that ban felons and those with some types of misdemeanors from owning guns, ERPOs allow people to take into account arrests that didn't result in a conviction or even just simply complaints. So while suicides and homicides are not reduced, you know what is increased by these things? Gun seizures. That's what increases. Not crime, not violence, but the seizure of citizens' guns, law-abiding citizens' guns. Kind of in summary, and I can break this down for you if you'd like. I did bring some statistics. But red flag laws have no significant effect on murder, suicide, the number of people killed in mass shootings, robbery, aggravated assault, or burglary. But there is
Wrap it up.
I am. And there's some evidence that rape rates do rise. These laws do not save lives, and RAND and the the Crime Prevention Research Center have numerous studies on this issue. And with that, I ask that you oppose the bill.
Members, questions?
I'm sorry, support. Excuse me. I was thinking of the last one. Thank you.
Representative Little.
Thank you, Chairman. CJ, you mentioned gun seizures. That was not kind of the path that I was thinking through this bill on. What gun seizures are you talking about?
So when an ERPO is in other states, and keep in mind there are 19 states plus DC, only 2 states have had them for any significant amount of time to be able to register these things. But in those states, once you have an ERPO, not only does it say you can have guns, but they're actively going into the homes and confiscating these guns to make sure that you don't have them, or they're requiring.
Who's they, CJ?
I'm sorry?
Who's they?
You've got California, DC, New York, Illinois, New Mexico, Oregon, Washington, Hawaii. There are others.
But it's like, is the sheriff's department or the police department coming to your house and literally physically removing them and putting them off-site somewhere?
It's either you've got the sheriff's department, you've got your local law enforcement, or you've got your state equivalent of what's like DPS here in Texas.
Okay, so Speaker Moody a little while ago referenced the full faith and credit of the state of Texas being applied to out-of-state orders. So I hope this is not true, but if you have a California ERPO, in California, it sounds like local law enforcement would go to your house and remove the firearms and put them somewhere else. If you have a California ERPO and that person comes to Texas, are we doing the same thing?
So I would say no, because unless you still, in order to go into the home, you still have to have some sort of probable cause. Generally, when an ERPO is issued in those states, they know that the person has a gun and they've confiscated them. The mere fact that someone has an ERPO and they come to Texas, I don't think would be probable cause or reasonable suspicion to simply enter the home and start deciding if they can take things. But if law enforcement does know that they have a firearm and an ERPO is in place that we recognize from another state, I believe then yes, that would be probable cause to be able to go and strip that person of those guns if we're going to honor those ERPOs.
Okay, thank you.
Members, questions? Thank you, sir.
Thank you. And again, vote for the bill.
Chair calls Nicole Golden. Ma'am, you show registered as Nicole Golden, Executive Director of the Texas Gun Sense, and you show against registered the bill. Is that correct?
Yes, correct. Thank
All
you,
right.
Chairman.
Thank you. Go ahead.
Yes, good morning, Chairman and members. My name is Nicole Golden. I'm the Executive Director of Texas Gun Sense. We respectfully oppose SB 1362 and do wish to demonstrate that extreme risk protection orders, or ERPOs, are effective, safe, and legal. ERPOs balance robust due process procedural safeguards with timely intervention to prevent harm. By authorizing the temporary removal of firearms and prohibiting individuals from purchasing or possessing firearms while the order is in effect, ERPOs provide a critical opportunity to prevent mass shootings, homicides, and suicides. The bill itself defines ERPOs as having the primary purpose of reducing firearm death or injury, And with more than 4,000 Texas gun deaths a year, this is something we should be doing more of, not less. There's evidence that ERPOs have averted tragedies around the country. One case in Florida, which has actually issued the largest number of orders since passing the measure after the Parkland shooting, involved a 30-year-old highly intoxicated subject in crisis who armed himself with an AR-15 and chased a group of students. That subject was served an ERPO and a year later had turned his life around. The ERPO expired and the subject had no further contact with law enforcement. ERPOs from other states are specifically drafted with preservation of due process and have not been found unconstitutional on those grounds. Michigan, for example, establishes criminal penalties for petitioners who knowingly and intentionally make a false statement to the court, and no petitioner has been charged with this offense at this time. As far as I'm aware, the courts have not found ERPOs violate the right to bear arms or the right to free speech. The only case that did, RM versus CM, was reversed. Further, the Supreme Court said last summer that it does not violate the Second Amendment to deprive someone of firearms if they pose a credible threat to others. Let me be clear, the bill appears to us to say that not only will Texas not be adopting its own ERPO, but even when a judge reviews all evidence from in another state and determines that a person is an immediate danger to self or others, we will prohibit and even punish entities who seek to enforce that ERPO here. So I'm having a hard time understanding how we might justify allowing a tragedy to happen knowing that we could have prevented it in our state. In conclusion, I just want to say a recent survey indicates that 88% of Texans, including 81% of Republicans, support ERPOs. Simply put, this bill is out of step, and I really thank you for your time today.
Thank you. Members' questions? Representative Little.
Thank you, Chairman. Nicole, you heard Kimberly's story earlier. She goes to the VA, says some things they don't like, and then a panel of people, without a hearing, issue an ERPO that can take her guns away. Is that right?
I don't know her case, and I've reviewed other cases and have not seen that documented.
So you would agree with me that that should never happen?
I don't know the specifics of her case, so I can't comment. I'm sorry for the tragedies that she's been through and the struggles that she expressed.
No, I'm just wondering, as a legal principle, we don't allow bureaucrats behind closed doors without a hearing to take other people's guns away in the United States of America, do we? We don't do that, right?
Yes. We've reviewed ERPOs and consulted with experts around the country, and as our understanding is there are protections built in. I don't know the specifics of her case.
Thank you.
Representative Bowers.
I just want to say thank you to Ms. Golden for your comments, and I just want us to remember that it should be about public safety, right, and safety of human beings. And you know, I know that this issue can be really divisive, but we have to put life over our personal possessions and consider that as, I would hope, more heavily weighted.
Thank you, Representative.
Thank you.
Thank you.
Thank you so much.
Chair calls Nancy Zars. Ms. Zars, we show you registered as Nancy Zars, psychologist, representing yourself against the bill. Is this correct?
Correct.
Thank you. Go ahead.
Good morning. I am Dr. Nancy Zars. I am a forensic psychologist. I oppose Senate Bill 1362. As I said, I am a forensic psychologist, a professor emeritus, a small business owner, a person of faith, and a parent. As a forensic psychologist, I worked in federal law enforcement. In fact, I had a contract with the FBI's Countering Violent Extremism Unit. As a professor, I taught violence risk assessment at the graduate level. In my consulting business, I specialize in violence assessment and prevention, all of which informs my opposition to this bill, which prohibits issuing and enforcing extreme risk protective orders, also known as red flag laws. We know, based both on research and lived experience, that violence and mental health concerns are on the rise. We all hear stories of increased rage, anxiety, depression, and emotional distress, along with an escalation of suicide and violence. We see it in our children, our families, our friends, our coworkers, and in our houses of worship. Red flag laws do not permanently remove guns from people or from homes. Instead, following a court hearing with due process and a judge's ruling, firearms are temporarily removed from those in crisis who are deemed to be a danger to self and others. By removing the lethality of a gun, we de-escalate crisis situations. Although often associated with domestic violence, extreme risk protective orders apply to all relationships, like a parent concerned about an adult child, wherein a red flag law can reduce the risk both of violence and of suicide. This law also makes it a crime to enforce legitimate court orders from other states, thereby endangering Texans and increasing the risk of gun violence here, including school shootings, workplace violence, and mass casualty violence. Studies show that 88% of Texans support red flag laws. Red flag laws have been proven to reduce gun-related homicides and suicides in other states, including Florida and Connecticut. I urge you to vote against this law and thereby reduce homicide and suicide in Texas. Thank you.
Thank you. Members' questions? Thank you. Chair calls Laura Miller. Laura Miller. We show you registered as Laura Miller, representing yourself, and we show you against the bill.
Yes.
That's correct. Go ahead.
My name's Laura Miller, and I oppose SB 362. The bill claims that red flag laws take away a person's right to due process, keeping or bearing arms, and free speech. But it doesn't say that these are temporary measures, and somebody can petition to get their guns back. There are times when we temporarily take away civil liberties. The president can just decide to go to war. If our country's under threat, why should we not take extreme measures when a domestic abuser is threatening to use a gun or kill, or someone is threatening to commit suicide? My personal experience with this is my daughter was feeling suicidal on New Year's Eve because that's a time when people feel really lonely. And she called me on the phone and told me she had walked all the way to the gun store, but then turned around and walked home without going in. But what if she didn't? What could I do if she decided to buy a gun now? And I just feel helpless to help my child in this situation. I live with that every day. And even people propose common sense laws like extreme risk protection orders. No laws get passed to keep guns out of the mentally ill, or not ones that are always working. Someone mentioned that we don't know what a Texas red flag law would look like. And I'm not seeing any bills that will help this situation passing in the legislature. So I'm just looking for, if this is something we're so concerned about, could you please find something that would help me help my son? Could you pass some gun laws that would? I'd like to see that. Just help keep my mentally ill child safe. Thank you.
Thank you. Members' questions? Representative Bowers.
I don't really have a question. I want to thank Ms. Miller. And that's sort of, what my earlier question for the bill sponsor was with Chairman Hefner, just wondering about the impact on domestic violence and mental health. So thank you very much for the courage to come and advocate for your son.
Thank you.
Mm-hmm.
Thank you. Chair calls Dakota Lee Moyers. We show you registered as Dakota Lee Moyers, representing yourself, and you show registered for the bill.
Yes, sir.
Thank you. Go ahead.
Hello, my name is Dakota Moyers. I'm a Navy veteran. I have served my country honorably and without regret. But right now I want to talk to you about what happened to my family because of risk protective orders and red flag laws. as you heard from my wife earlier, Kimberly, she was red flagged by the Veterans Affairs Hospital. We were told that the red flag had been removed, but without informing us, they had replaced it. While going to the VA for a simple dental appointment, she was arrested without warning by Conroe police in the Conroe VA clinic. She spent 36 hours in jail while waiting for a PR bond, and we have been fighting this so that it doesn't happen to other veterans ever since. I was put in a position where I had to choose, being a veteran myself, whether to stand up for my wife and tell the police officer that he is wrongfully arresting her, or I had to stay back to be with my then 1-year-old daughter. Because I am a veteran, I am also subject to those policies set by the VA. So if I were to be in the way, I would have been labeled disruptive and then red flagged. I had to stay back so I can be a protective shield for my daughter, so that no one would step in, such as social services, to take her away. For those who think that red flag laws there is no red flag law in Texas, I would like to show your attention to the Texas Two-Step program. You can see this at texas2step.org. They have superseded the law in risk protective orders by not sending police directly to the homes of people that are looking to ERPO, but sending the family members to remove firearms from them to then turn over to be safely stored away by police. This supersedes due process, takes away any rights, and it is employing the family members to act as another arm of the law unconstitutionally.
Please wrap it up.
Lastly, I'd like to address you, Ms. Bowers, and you said that with another person that was testifying here earlier, that we need to put life over possessions, when that is not the argument here. This is about putting liberty over life, and it was one of the very basis of where our country was founded. You know, give me liberty or give me death.
Thank you. Thank you. Members, any questions?
I don't have a
Representative
question,
Bowers.
but thank you, Chairman. I do have a comment to you, sir. My husband is a Gulf War veteran as well, so thank you for your service, and I do understand, but I certainly will stand firm on life over personal possession.
This is not a personal possession. This is a right. This is what
Sir,
it is to be put in place
I would
so
love
we can
to
protect
talk to you
ourselves.
about this at a later time. The chairman has already called time, but I will, and so you can certainly call my office or come by, because I am always willing to listen. But I do believe in protecting life. And, you know, when we talk about being pro-life, we have to consider that in all areas and all realms. So for me, and no disrespect to you, sir, I certainly would say that life should be more heavily weighted than a personal possession. And my husband and I disagree on this issue. So you need to understand that he can still respect me and disagree with what a firearm is. So I don't have any disrespect for you. If you feel that way, I again applaud you and commend you on your service. But I'm not going to sit here and be told that life should outweigh a personal possession, if that's the way.
I'm not saying that your argument is wrong. I'm saying it's the wrong argument.
Well, that is the same thing.
No,
Thank
it's
you,
not.
sir. Thank you.
Thank you, sir. One question. Mr. Morris.
Excuse me.
Representative Little.
Thank you, Chairman. I'm really trying to understand what happened at the dental appointment. I've got to know. What happened that...
My wife checked in for her dental appointment, was confronted by VA police saying that she was not allowed to be there. Unbeknownst to us, she had been red flagged.
But what prompted the red flag? Do you know?
From what I know, I don't know, because the last time she was red flagged is because of a disagreement between her and a nurse several years ago. and the nurse just filed a complaint internally within the VA, and unbeknownst to us, she was red flagged.
Okay. Thank you.
Secret hearing, secret bureaucratic hearing. Had no idea that it happened. Just ended up going to a VA appointment just to find out that she had been red flagged.
Thank you for your testimony. Appreciate it.
Thanks.
Chair calls Timothy Mabry. We show you registered as Timothy Mabry, representing yourself for the bill. Is this correct?
Yes, Chairman, that is correct.
Thank you. Go ahead.
So I'm Timothy Mabry. I am a seventh-generation Texan, and my family has been here in this territory before the United States was the United States. And one thing that I have noticed is when it comes to our laws, we have the Second Amendment laws on the book that's saying we have the right to bear arms. These are constitutional rights that we have. And by adding these red flag laws, we're saying that there's provisions to the laws that exist on the books to erode our constitutional rights. I guess my question is, if you do a red flag law and you're willing to give up that right, what else are we willing to give up? Being a Navy veteran fire officer as well, I have seen the manipulation of law enforcement and first responders firsthand, to where you can get somebody to say special words. You know how to do that. And it's sad to say, I learned how to do that myself, to where I can get somebody to say in a conversation the special words that I want to hurt myself or others. You get to learn those skills. And I have seen that firsthand and weaponized. In the first responder and mental health worlds, I have seen this weaponization take away people's rights and freedoms against their wills. And this is what I'm standing up against and saying, where are we going to stop with this? We are in a mental health crisis here in this country. And I have seen veterans have their guns taken away. Me, myself, I went through a mental health crisis with the VA, and I was terrified. I'm like, before I even went to seek help and before I told the therapist anything, I had to clarify, how is this going to get reported? Is this going to affect my job and my livelihood? I was terrified of that because we've seen in other states where bureaucrats can make a decision on you, and now they come and take your stuff. And for me personally, I've had situations where having a firearm was protection because we've been violated by having someone break into my house with direct threats of them coming back in and finishing the job. Where my wife, when we got broken into, my wife happened to walk in as the criminals were walking out. And for a while, the law enforcement told us, hey, we are we're concerned that they may come back to your house. So for me, having that weapon and going through the VA system, if they would have taken that from me, that would have caused even more anxiety and more fear. And that's what I want to stand up against and just say, hey, look, we have a systemic problem.
Please wrap it up.
Yes, sir. And it's a mental health issue. It's not a gun. It's a mental health crisis that needs to get solved and to enforce laws that are already on the book. Just for instance, the people who broke into my house were convicted of murder and were out on parole. That's just to hear. So that I am in support of this anti-red flag law.
Thank you. Representative Bowers.
Thank you, Mr. Mabry. This is great conversation before I've had breakfast this morning, but, and this is something that I am terribly passionate about, and I think people in this building know that, but I can certainly respect what you're saying because I think some of the things you said when you talked to that therapist you were mindful, right? And you were careful in what you were saying because you knew that those trigger words might make them seize your possession, right? And I think that's the direction I'm trying to go with this, that, I do feel that a weapon is a personal possession. I do feel that. As I already said, if my husband's watching, he's probably not. But I can tell you what, he does not agree with me. He does have firearms, and I can tell you, to me, I think you handled it right when we're talking about what can happen to veterans. And I thank you for your service, and I thank you for your testimony this morning. Thank you.
Thank you for hearing me. And
members' questions. Thank you, sir.
Thank you.
Chair calls Wayne Nunn. Mr. Nunn, we show you registered as Wayne Nunn, Texas State Rifle Association, and yourself, and you are registered for the bill. Is this correct?
Yes, sir, Mr. Chairman.
Reminder about the 2 minutes.
Yes, sir.
Thank you.
Chairman Louderback and members of the committee, I'm Wayne Nunn. I'm past president of the Texas State Rifle Association, and I'm here to speak in the affirmative for Senate Bill 1362. The Texas State Rifle Association fully supports this bill and recommends passage. Several states have passed laws regarding implementation of red flag laws with a myriad of different requirements. But one thing they have in common is they tend to deprive the individual of the right to keep and bear arms and their personal property. Virtually all these laws can be deprive an individual his right to possess a firearm as flimsy as a neighbor or a disgruntled parent or even a person driving by seeing something that they don't feel good about. So they're deprived of a proper hearing. Even the ACLU has stated that people who are not allegedly to have committed a violent crime should not be subject to severe depredations of liberty and the absence of clear, compelling, immediate showing of need. The breadth and limit of the standards for applying granted red flag are a great concern. A study conducted by John Lott, a statistician, has shown that red flag laws have virtually no effect on murder, violent crimes, aggravated assault, mass murders, mass shootings. And a DOD study has stated even certain red flags are common amongst mass shooters. Almost none of the people were actually bent on committing that crime. So who is able to actually distinguish the difference between a loudmouth or just somebody just shooting off? All of us Texans want us to keep guns out of hands of those who are bent on evil and doing murderous things. But red flags are not the way to accomplish this. Again, TSRA
Thank
wants
you,
to
sir.
support the bill, and I'm ready for this questions. Thank you.
Thank you. Members' questions? Thank you, sir.
Thank you.
Chair calls Michelle Venegas Matula. Calling for Michelle Venegas Matula. We show registered representing Texas Unitarian Universalist Justice Ministry and self, and she registered against the bill. So he is not testifying. Is there anyone else who wishes to testify on, for, or against Senate Bill 1362? If not, the chair recognizes Chairman Hefner to close on the bill.
Thank you, Mr. Chairman. Thank you all again for hearing Senate Bill 1362 today. Again, this doesn't change any risk protective order processes currently in Texas. This simply prevents local governments from instituting their own going forward. And with that, I close.
Representative Moody. Mallon.
Thank you. Just one last comment. I think, thank you for bringing this up and for this discussion on your layout. If one of the witnesses I'd like to ask could just talk to my office about, I think it was Dr. Grisham, CJ, about the increased rate numbers, I thought is what I heard. So if you could contact my office.
Yes, ma'am.
Thank you.
Thank you, Chair. If there's no objection, the bill will be left pending.
Thank you all.
The chair hears none, and Senate Bill 1362 is left pending. 1379. 1379. Chair lays out Senate Bill 1379 and recognizes Chairman Cook to explain the bill.
Thank you, Chairman Louderback and committee members. I appreciate the opportunity to lay out Senate Bill 1379. This is a bill that's been originally filed by Senator Flores in the Senate, which responds to the alarming rise in financial fraud in Texas, particularly check fraud. According to the U.S. Treasury Department, check fraud has surged by 385% since the COVID-19 pandemic, with international criminal organizations fueling this spike through increasingly sophisticated schemes. Senate Bill 1379 amends Section 32.21 of the Texas Penal Code by increasing the penalty for forgery from a Class A misdemeanor to a state jail felony. The bill further enhances penalties based on the type of forged documents and the value of property or services obtained. It imposes stricter consequences for forging high-risk instruments such as checks, government records, and financial contracts, and includes an enhancement if the crime targets an elderly victim. This legislation sends a clear message that Texas will not tolerate fraud, and it gives law enforcement stronger tools to combat this growing threat. I'm available to answer any questions and would like an opportunity to close when appropriate, Mr. Chairman.
Members' questions for Chair Cook? Commissioner Bowers? No questions. Okay. Thanks, sir.
Thank you.
Chair calls Jessica Palash. I don't feel real confident in the pronunciation of that.
You were close.
You want to advise me?
Good morning. It's Palachi.
Jessica Palashi, we show you registered as SEVP, Chief Customer Experience Officer, Texas Bankers Association, First National Bank of Texas. Is that correct? And you show registered for the bill?
That's correct.
Okay, thank you.
Thank you. Thank you, Mr. Chairman and committee members. My name is Jessica Palachi, and I'm the Chief Customer Experience Officer here on behalf of First National Bank Texas and the Texas Bankers Association to testify in support of Senate Bill 1379. Thank you to Representative Cook for sponsoring and to Senator Flores for filing this bill to increase the penalties for forgery. In recent years, check fraud has surged up over 400%, which has significantly impacted the safety and soundness of banks by increasing financial losses, operational strain, and reputational risk. The growing sophistication and speed of fraud schemes, such as check washing, mail theft, and counterfeit check creation, have made it more difficult for banks to detect and prevent fraud in real time. The rise in organized crime involvement in the use of digital channels to quickly cash or deposit fraudulent checks have escalated the speed and volume of fraudulent activity, putting additional pressure on banks' resources and risk management frameworks. To combat the increase of check fraud, we have committed resources to help address this criminal assault. Educating both our customers and our employees has been an important tool to combat check fraud. Raising the awareness of how to detect and prevent fraudulent check items to avoid their negotiation has been an important deterrent. Despite our educational efforts, customers may still fall victim. Our customer, an elderly veteran, fell victim to fraudsters. He was targeted through a technology support scam, which is a criminal perpetrating as a technologist that had identified a compromise on his personal computer browser and offered his assistance to remediate. Our customer engaged and provided all his personal information, to include his bank account and routing number, which allowed the criminal to create checks, which he proceeded to negotiate fraudulently throughout several markets across Texas, further spreading the financial loss to the local businesses that accepted these fraudulent instruments. Within a matter of days, the criminal had stolen over $80,000 from our customer. These criminals were relentless and continued to target our customer for months. Our bank security and customer experience teams were able to finally cease the attacks by working closely with our customer each time the criminal tried to regain his new account information.
Thank you for your testimony.
Thank you.
Members' questions? Thank you.
Thank you.
Chair calls Timothy Mabry. We show you registered as Timothy Mabry, representing yourself for the bill.
Yes, sir, that is correct. So
Okay, thank
I'm
you.
Timothy Mabry, and I'm for the bill. And one of the big things is, for me, I do business consulting, and I'm a part of a lot of councils, business councils and economic in San Antonio. And just recently, I was at a meeting where they were talking about how the fraud is ramping up severely, and that how local law enforcement does not have the capability to do so. So they have set limits of like $1 million, what they're able to really target. Anything below that, they really do not. And on the other part of that too, is we don't have the capability and infrastructure to really talk throughout Texas. So what each law enforcement agency does is they have to write it up in their own. So there's not a lot of communication talking back and forth. So if there's a fraud cell out of San Antonio, you can go to Austin or even out of state, and they're not talking to each other. And that's because it's not on the FBI's radar. You can only go to the FBI's radar if it's above $1 million. And that's creating a major problem with small businesses and a lot of the banking institutions that I work closely with, is that they want to pursue it. They write the claims and the cases up, but until it reaches a certain amount and gets turned over, then that's when they're able to have an impact. But if it's, like I said, less than $1 million and it's just San Antonio or one local area, you are out of luck. So that's where these sales are happening, is they're targeting people in different states, in different regions, because they know law enforcement doesn't communicate unless they become big fish.
Thank you. Members' questions? Thank you, sir. Is anyone else who wishes to testify on, for, or against Senate Bill 1379? If not, Chair recognizes Chair Cook to close on the bill.
Thank you, Chairman. Subject to any questions, I close.
Thank you, Chair. If there's no objection, bill will be left pending. Hearing none, Senate Bill 1379 is left pending. 1451. Chair lays out Senate Bill 1451 and recognizes Chair Cook to explain the bill.
Thank you, Chairman Louderback and committee members. Appreciate the opportunity to lay out Senate Bill 1451. This is also a Senator Flores bill. This one addresses the growing crisis of check theft and financial fraud across Texas. According to the U.S. Treasury Department, there has been a 385% increase in check fraud since the COVID-19 pandemic, driven in large part by international crime organizations using stolen checks to defraud banks and consumers. Senate Bill 1451 amends Section 32.24 of the Penal Code by increasing the criminal penalty for stealing or knowingly receiving a stolen, unsigned check or similar cite order from a Class A misdemeanor to a state jail felony. The bill targets individuals who intend to use, sell, or transfer stolen checks, which are often trafficked on the dark web and used to exploit financial systems. This legislation gives prosecutors law enforcement a stronger tool to deter and punish those contributing to organized financial crimes in our communities. Appreciate the opportunity to bring this bill. Happy to answer any questions. Would like an opportunity to close when appropriate.
Thank you. Members' questions? Yes, sir.
Thank you, Chairman.
Chair calls Kate Decker. We show you registered as Kate Decker, Texas Bankers Association. We also show you registered for the bill.
Yes, that's
correct. Thank you. Go ahead.
Thank you, Mr. Chairman and members. My name is Kate Decker, and I'm the Deputy General Counsel for the Texas Bankers Association. I'm here on behalf of our members in support of Senate Bill 1451. I first want to thank Representative Cook for sponsoring this bill to help address the growing crime of financial fraud in the state. At TBA, we represent nearly 400 banks across the state, from the smallest to the largest. Regularly, we meet with our member banks across Texas, and we hear from hundreds of bank employees. The number one complaint we hear right now is the problem of financial fraud and the negative impact this growing crime has had on the industry, and most importantly, the customers our banks serve. The banks are doing everything they can to help stop the fraud, but the criminals are working even faster. We need the state's help in combating this crime to protect the customers and the banks that work hard to serve our communities well. These financial fraud crimes are now being operated in large-scale, sophisticated networks, where stolen checks are not merely found and cashed anymore, they are now sold on websites to fund further criminal operations. We believe that increasing the penalty for the offense of stealing or receiving a stolen check when there is intent to use, sell, or transfer that check to another person will be a better deterrent to criminals and a stronger tool for law enforcement. Thank you for the opportunity to speak with you today, and thank you for your consideration of this bill.
Thank you. Thank you very much. Members' questions? Is there anyone else who wishes to testify on, for, or against Senate Bill 1451? If not, Chair recognizes Chairman Cook.
Subject to any questions, I close.
Thanks,
Thanks, Chairman. Appreciate the opportunity.
There is no objection. Hearing none, Senate Bill 1451 is left pending. The chair lays out Senate Bill 990 on behalf of Chair Smithy. Representative Linebacker, I'll go ahead and explain the bill. In June of 2024, a 12-year-old named Jocelyn Nungaray was murdered in Harris County, Texas. This shows a gap in the criminal justice due to the inability to impose a death penalty for the murder of children between the ages of 10 and 15. Under current Texas law, her killers cannot face the punishment that the Harris County District Attorney recommended, which was the death penalty. Forensic evidence later showed that Jocelyn was sexually assaulted by her killers. This was the reason that the prosecution could pursue the death penalty. It took an additional crime to pursue the necessary punishment for another crime. The purpose of this bill is to repeal Section 1B of the Code of Criminal Procedure. Section 1B refers to the section of the Penal Code that states that a person who murders a child who is between 10 and 15 years of age may not be sentenced to death. This bill would allow the death penalty to be an option as legal punishment for the murder of a child 10 years of age or older, but younger than 15 years of age. Expanding the death penalty to cover the murder of children up to 15 years old would send a strong message that such crimes have met with the most severe consequences. Members, any questions?
I have a question. I am just baffled how this is in statute and how this got there. Chairman Smithy, this is your bill. Do you have any idea why the law is this way, or how this happened?
I'm sorry to be late coming in.
Chair recognizes Chair Smithy.
No, I don't know the history of it, but it is interesting that we have that cutoff there because you have like a 12-year-old child, and we're not giving them that same protection. It's really unthinkable. Yeah.
I have no idea how this happened, how the statute got here, or why someone would put it in there. But I didn't know it was there.
Yeah.
Okay.
I don't have any good explanation.
Members, any other questions? If there are no further questions, we'll move on to witness testimony. The chair calls Kevin Trahan. We show you registers Kevin Trahan, Texas Defender Service, against the bill.
Yes, that's correct.
Thank you. Go ahead.
Good morning. My name is Kevin Trahan. I'm a staff attorney at Texas Defender Service. Children deserve to live free from violence, and Texas should pursue policies that protect the safety and security of young people. However, Senate Bill 990 will not prevent children from becoming victims of homicide. This is because the death penalty does not deter crime. The use of the death penalty also diverts important financial resources that can be used to support law enforcement and to fund violence prevention programs that protect young people from harm. I'm also concerned about Senate Bill 990 for a second reason, which is that this expansion would apply to a class of crimes that is materially different from deaths involving very young children. Very young children are likely to be killed in violent incidents that do not involve guns, like beatings and asphyxiation, and are most often killed by an older adult rather than another young person. This is part of the reason that deaths of young children are considered so reprehensible. Children 10 or older are most frequently killed in gun incidents. The perpetrators are usually their peers and are usually younger than 24, and these deaths usually occur during arguments and community street violence. Gun violence involving children is a tragedy, and there are many community-based intervention programs that prevent gun violence among young people. But expansion of the death penalty will not prevent gun-related homicides among young people, nor is the state prepared to support this expansion administratively or fiscally. There are exceptions, of course, but they are rare, and they are usually death penalty eligible for other reasons. For murders of 10 to 14-year-old victims involving especially reprehensible circumstances, most often there are already other aggravators available for prosecutors to pursue the death penalty. Those aggravators include categories such as murder in the course of a robbery, and sexual assault, and in kidnapping. It's the state's responsibility to reserve the death penalty for the worst of the worst cases. The reality is that gun violence involving young people would not meet this criteria in the perception of most Texans, and that is precisely the type of case that this expansion would cover. Of course, prosecutors can always use their discretion not to charge these cases capitally, Once this offense is on the books, though, prosecutors will face tremendous local pressure to prosecute these crimes capitally. I thank you for your time, and I've also passed around a one-pager from our organization, I guess a two-pager, for y'all to review.
Members' questions? Representative Little.
Thank you, Chairman. Kevin, I don't know that this is the day that you want to be doing this. All three of my children are 10 to 15 years old. Are my children not vulnerable in the same way that children under 10 are vulnerable?
No, certainly, that's not what I said at all. I believe, we should be protecting children, but expansion of the death penalty, as has been proven by statistics, does not actually prevent more crime. And secondly, children are certainly vulnerable from 10 to 14 years old, but they're in different ways than we see the death penalty usually being applied. So usually the death penalty is applied in cases, the death penalty is pursued in cases where the children is under 10 because like an adult beats them, or there's an adult involved, and those children are particularly vulnerable for those kinds of crimes. Just statistically, the types of crimes that would now be death eligible are statistically less likely to happen to children ages 10 to 14.
That doesn't make any sense to me. Now, you're anti-death penalty generally, right?
Our organization advocates against use of extreme punishment. So I'm not here for myself. I'm here on behalf of Texas Defender Service. So we advocate against the use of extreme punishment in Texas.
That's fine. It's in many ways a morally valid position to take. But can you articulate any rational basis for why children 10 to 15 years old, you can kill them wholesale without ever being subject to the death penalty in the state of Texas? Can you, help me make it make sense?
Yeah, so the state of Texas has, because the Supreme Court has said the death penalty has to apply to cases of the worst, you have to narrow it down. Texas has decided, I guess for decades now, that the death penalty is only going to apply to murder in the course of certain aggravators, and because the types of crimes that usually apply to children under the age of 10 are usually much more aggravated. I'm assuming that's why initially that was the age cutoff. Actually, it's in the one-pager, but if we were to expand the age range of death-eligible crimes to 14, Texas would be very, very out of step with the rest of the country.
Kevin, you're lucky Alexis Nugare isn't here.
Members' questions? Thank you.
Thanks.
Chair calls Nan Tolson. We show you registered as Nan Tolson, Texas conservatives concerned about the death penalty. We show you registered against the bill.
Yes, sir.
Am I correct? Thank you. Go ahead.
Good morning. Thank you all for your time. My name is Nan Tolson. I'm testifying in opposition of Senate Bill 990. I'm here as a lifelong Texan, a lifelong conservative, and as director of Texas Conservatives Concerned About the Death Penalty. We're a network of conservatives questioning the alignment of capital punishment with our values. I do first want to acknowledge the reason that we're here, which is the senseless murder of Jocelyn Nungray, and extend my prayers to her family. I'm very grateful that there are lawmakers that are seeking solutions to prevent more vulnerable lives from being taken at the hands of heinous criminals. But we believe that Senate Bill 990 is not conducive to that safer or more just future that Texas children deserve. One of our concerns is the fact that the death penalty is an ineffective deterrent to violent crime. Among the multitude of research is a 2009 national poll where police chiefs ranked the death penalty last among ways to reduce violent crime, and they considered it the least efficient use of taxpayer dollars. Senate Bill 990 would also increase the fiscal burden that the death penalty places on taxpayers. Here it costs 2 to 3 times more to sentence someone to death versus life without parole. Senate Bill 990 would lead to even more money and resources wasted when we could be investing in proven crime prevention strategies. We believe that Texas should certainly be in the business of keeping us safe and securing justice, but in a responsible, efficient way that protects life and liberty. This is something that Senate Bill 990 would fail to do. Governments tend to encroach on people's lives, waste their hard-earned dollars, and invest in ineffective and irresponsible solutions to public ills. The death penalty is the epitome of this. It's an expensive and it's an arbitrary component of our justice system that places too much hands in the power of the state with no real evidence that it delivers the safety, justice, or deterrence that it promises. We should be tough on crime. We should hold violent criminals accountable, and we should protect innocent lives. And we can do all of this without expanding the death penalty. So I please urge you to oppose Senate Bill 990 and pursue more effective methods to keep our communities safe. Thank you.
Members' questions? Thank you.
Thank you.
Chair calls Kristen Houlet Cuellar. We show you registered as Kristen Cuellar, Texas Coalition to Abolish the Death Penalty. And we show you registered against the bill.
Yes, that's correct.
That's correct.
And thank you for that
Thank you. Go ahead.
pronunciation. That was spot on. Amazing. Good morning, Chairman Louderback and committee members. Thank you for the opportunity to address you today. My name is Kristen Houlet Cuellar. As the Executive Director of the Texas Coalition to Abolish the Death Penalty, I'm here in opposition to Senate Bill 990. The members of our organization abhor violent acts against children of any age. We are mindful of the devastation murder inflicts on families and express our deepest condolences to the family of Jocelyn Nungray and all who have suffered such an inconceivable loss. Our opposition to this bill should not be construed as sympathy for those who kill children, but rather our position that Texas can already hold people who are guilty of these heinous crimes accountable and protect society without expanding the application of the death penalty. I have three main objections to the bill. First, this bill reinforces the inherent arbitrariness of the Texas death penalty and the broad scope of our capital statute. It expands upon what is already an arbitrary standard for a victim's age, a standard that will always leave out those above the line. If this bill becomes law, the murder of a 14-year-old child could be punished differently from the murder of a 15 or 16-year-old child or someone's 19-year-old child for that matter. Secondly, the bill will not deter offenders nor prevent the murder of children. In 2011, the 82nd legislature raised the aggravating age for a charge of capital murder from 6 to 10. Regrettably, that has not prevented crimes against children of those ages, just as the earlier version did not prevent the murders of children under 6. We know from study after study that the threat of the death penalty does little to prevent violent crimes because perpetrators rarely consider the consequences of their actions. Lastly, use of the death penalty in Texas has decreased significantly over the last 2 decades. We believe SB 990 moves our state in the wrong direction by expanding the scope of the death penalty, and I urge you to oppose this legislation. Thank you so much for your time.
Members, questions? Thank you.
Thanks.
Chair calls Timothy Mabry. Again, we show you registered as Timothy Mabry, representing self, and we show you for the bill. Is that correct?
That is correct.
Thank you.
It
Go
just
ahead.
so happened that y'all had multiple bills that I aligned with. I was like, well, that's cool. With SB 990, for me, I have 2 children under the age of 3. And I have seen the issues of our law enforcement system not enforcing violent crime against children and adults. And my personal belief is that we are not enforcing these rules, and it's creating a softening effect. That if you go out and commit a murder of a child or of another individual, you hear, hey, I want life in prison. I want to get off from this. I have seen personally people who get convicted of murder get out of the streets and what they do. As I testified earlier, a violent offender broke into my house. What I didn't tell you is that my wife, when she pulled up to the house, they were still in there. And they, at that time, could have killed her. The only reason we're certain that they didn't, according to law enforcement, was that she had left a pregnancy test on the counter. But we had a violent felon who got out on parole for murder and broke into our house. So my true belief is that we need to enforce these rules and make them stricter. So I'm for the death penalty, and I even say expanding it. It was mentioned earlier about the cost of it. Why don't we bring back the old rules? If it's beyond a shadow of a doubt that you are convicted of a murder or of a heinous crime against a child, and I mean you have undeniable proof, eyewitness testimony, DNA evidence, video conviction, there's no doubt. My belief is set up the old hanging tree and hang them right then and there. This way we save the taxpayer money, because it costs more money to house somebody in prison than it does what should it be. The death penalty is extremely expensive. So if you want to save taxpayer dollars, if it's beyond a shadow of a doubt, hang them right there. That's a lot cheaper than that.
Thank you, sir. Appreciate it. Members, questions? We'd like to recognize Representative Money for our last witness.
Yeah, I know it's the
Any
last
que-
one.
members'
Just
question?
a comment.
Comment? Chairman.
I know we're short on time, but I don't know how serious you are about the testimony you just gave in terms of hanging people in the center square on site. Like, not a lot of due process in that, is there?
No, there
Like,
isn't. I'm
there
saying
isn't.
they're
This
convicted
is the
without a
part.
shadow of a doubt. Like, they're at criminal. Like,
there's-
when it comes to sentencing, that's where.
I just look the contradiction that I continue to struggle with is witnesses in the same day, insufficient due process for property, but we're going to hang you in the city square because we feel like this is the better way to do that. Like the concept of deprivation of life in what you just described is zero due process. And in the same hour of time block, the deprivation of someone's property, you couldn't put enough due process in.
I would like to ask you on that one, how is it not due process when it goes to the courts? That's just a question.
You just said if there's a piece of evidence or video or whatever, I mean, there's still rules that we have to follow, and the ability to confront witnesses, and I mean, a myriad of other rights that the accused have. Those are enshrined in the Bill of Rights, and that the whole scenario you just laid out flies in the face of. And so, we like to pick and choose which constitutional right we want to attach certain due process to, and certain ones of them are continue to be eroded. And I didn't mean to go down that rabbit trail because I know we've got to get to the House floor, but it's just a little frustrating when you hear these two things in the same course of an hour. And I can't believe that's an actual serious position you would take, so I'm just going to take it as more of hyperbole.
Thank you. Representative Bowers.
It's not a question for it's a comment, so it's not for you, but I think.
Keep it short.
The author, absolutely. Thank you, sir. The author or bill sponsor is Smithy, Chairman Smithy, and I'll talk with him because my concerns are with racial equity and prosecutorial biases. So, I just want to know how the legislative oversight might ensure equity in implementation of the statute. So I'll talk to him on the floor. Thank you.
Thank you. Thank you. Chair calls Samuel Echevarria Cruz. We show you registered as Samuel Echevarria Cruz, representing yourself against the bill. Is this correct?
This is correct.
Thank you, sir. Go ahead.
Thank you, Chair Lauterbach. Thank you, members. I come as a concerned Texan with any expansion of the death penalty. Even as a father of 5, with 2 into this age group, it concerns me that we're moving in the wrong direction by expanding the death penalty. We've already heard the data that shows that really the death penalty does not do what we think it does in this state. It never has. But what it has is a legacy of inequity, a legacy of oppression. And anytime that we think about the death penalty use of justice, we must also think about the death penalty's increase of injustice in Texas, with so many high-profile cases of exonerations and of possibly and quite confidently people executed in this state who were actually innocent. We need to be very careful. I understand the arbitrariness of a line, absolutely, and I'm curious too as to the history of how this line was set from 10 to 15. But again, I will concur, especially as an educator, that a lot of this age group is susceptible to gun violence with a lot of peers who may be over the age of 18. And so there we have another exacerbating challenge there of young people and the rift of gun violence that we have, the epidemic that we have. This does little, this does nothing to address that issue. We have better tools, we have better places to put our money into healing communities and into ensuring that more justice, not less, is actually meted out to those who deserve the justice of incarceration, of life in prison. But the death penalty itself is so problematic, and many, many states are moving against it, states that are conservative in nature, and the majority of people over and over on surveys show in Texas that they're moving their position away from the death penalty, primarily because of so much injustice that has been attached to the death penalty. Thank you.
Thank you. Members, questions? Thank you. Is there anyone else who wishes to testify on, for, or against Senate Bill 990? I'll close on the bill. Bill closes. At this point in time, any questions? Okay, go ahead. Go ahead. Thank you. Thank you, Chairman Moody. If there's no objection, the bill will be left pending. Chair hears none, and Senate Bill 990 is left pending. Just a minute, we'll get the paper, we'll get the right language. Jill Little makes the, Representative Little makes the motion in writing on the Betancourt Smithy of Senate Bill 990. I move that Senate Bill 990 be reported favorably to the full Committee of Criminal Jurisprudence for consideration to be reported out favorably to calendars. Hearing the motion.
Okay, I didn't know. I was just.
No, you're good. Okay, so you're gonna say, sorry, why do you make it bigger? Oops. Okay. So you're gonna say this part right here.
The question occurs on the adoption of the motion. Clerk, call the roll.
All right, Chair Louderback. Representative Bowers.
Nay.
Representative Little.
Aye.
Representative Money.
Aye.
Representative Moody. Okay, so you have a quorum. So you're gonna say, there being
There
three
be
ayes, 2 nays.
3 ayes and 2 nays.
Motion
The motion prevails.
And then that's all for that one, and then here's the second one.
A motion in writing by Representative Little. I move that Senate Bill 1362 by Hughes Hefner be reported favorably to the.
I'm so sorry. We can't do it report favorably. We need to say, I'm sorry, I didn't catch this. So this is what it'll need to be, that the subcommittee, because we, as a subcommittee, don't have the power to move the bill, so it needs to be that subcommittee chair informed the committee chair. Right. That the subcommittee has completed deliberations and recommends that Senate Bill 990.
1362.
Well, we gotta fix 990 be scheduled for consideration by the full committee. So just, if you'll just, we'll just make this your motion in writing since it's proper. Okay, so I'm so sorry, we'll have to redo.
Go back to 990.
Sure, yeah, to redo the vote
Yes,
to
it was,
reconsider.
yeah.
Following motion in writing by Representative.
Well, I would just say, well, we need to do a vote to reconsider the previous motion.
Representative, a vote to reconsider the previous motion
Is
made
there
by
any-
Representative Little.
Is there any?
Motion, is that
the-
the motion in writing or the motion
the
to
motion-
report to the full committee?
Well, the motion.
What are we reconsidering?
So it'll be both, because the motion in writing does say the motion that it be reported. So that all was all one motion. So we'll just say, so you'll need to say reconsider the motion in writing to move that Senate Bill 990 be reported favorably. Does that sound like it?
Good, good, Joe.
That would cover it.
Reported favorably to the full committee.
So just go and read this. There'll be a motion to reconsider, a motion in writing to move.
There'll be a motion in writing to reconsider Senate Bill 990
May reported favorably.
Be reported favorably to the full committee,
And a motion to reconsider.
and a motion to reconsider,
The motion in writing.
a motion in writing
Made by Representative Little.
by Representative Little.
Okay, so now, is there objection to reconsideration?
Any objections?
To reconsideration.
Correct. So, no, so, because we're about to do the new motion.
I'm good with it. I just
Okay.
didn't know if he needed to say.
So, so is there any, okay, hearing no objection, so now say.
So hearing none,
So the motion's gonna be the two motions will be reconsidered.
motions will be considered. The two motions will be
Okay.
reconsidered.
So now read this.
Following motion in writing by Representative Little, I move that the subcommittee chair inform the committee chair that the subcommittee has completed its deliberations and recommends that Senate Bill 990
Be scheduled.
be scheduled for consideration by the full committee. Question occurs on the adoption of the motion. Clerk will call the roll.
Chair Lauterbach.
Aye.
Representative Bowers.
Nay.
Representative Little.
Aye.
Representative Money.
Aye.
Representative Moody.
No.
Okay, 3-2, the motion. Oh, sorry.
There being 3 ayes and 2 nays, the motion prevails.
Okay, so now for his second one, just read this and just sub in
The following in motion by Representative Little,
motion in writing.
I just said that.
Okay.
I move that the subcommittee chair inform the committee chair that the subcommittee has completed its deliberation and recommends that Senate Bill 1362 be scheduled for consideration by the full committee. The question occurs on the adoption of the motion, and clerk will call the roll.
Chair Lauterbach.
Aye.
Representative Bowers.
Nay.
Representative Little.
Aye.
Representative Money.
Aye.
Representative Moody. Okay, 3-2.
There being 3 ayes and 2 nays, the motion prevails.
Okay, then let's adjourn.
Do it.
We need to adjourn.
Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to the call of the chair. Thank you all.